bundles, I'm told it's an IT glitch to do with date of lodging and date of filing hard copies and so on and so forth.
It doesn't matter what the bundles say. What matters is what you say. If the bundles have got all sorts of pages all over the place, it doesn't matter as long as you can tell those of us who use this electronic system what page it is.
Well, that's the reason is that if the electronic pages were only loaded recently and we haven't had access to those pages, and that has renumbered things in ways that are totally unpredictable. So that's how it's arisen.
What a shame. Never mind.
It's an extraordinary shame. We believed we had the same version as the electronic, and we were not to know until it transpired that it was otherwise. And so I'm sorry.
You have our sympathies.
Thank you very much. What we are having is a transcript. We will mark that up with what we believe to be the correct page numbers and let the board have that.
That's totally unprecedented to have transcripts of hearings on
yes.
the board. No, it's not totally unprecedented. It's very, very rare.
Well, as it turns out, it might be helpful. So, if for no other reason than the references. Yeah.
Thank you.
Yes.
Very much.
Please, Mary. One issue on the facts, if I may, very briefly. I will give you some page references and then 2 points to deal with. And then, with the board's permission, I would like my learned junior to follow briefly on the comparative law. Facts. 5 points. Firstly, it's not appropriate simply to build on Dr. Lightman's 2 to 4 hours on the basis that it wasn't challenged in our submission, because it was challenged, and the reference is red 266, black 173.
It was put in very broad terms, said it would have taken hours, wouldn't it? The challenge was put in very broad terms.
It was, but he then went on to deal, and this is pages 279 to 80 in red, 186 to 187 in black, and I can't tell what the electronic one is, where the papers were then put to him, and concluded at lines 1 to 19 on page red 280.
Sorry, what do we mean by red and black?
I've got 2 numbers on the bottom of my
page.
page.
I see.
Red are what I thought were the electronic ones.
Yes, well, you could be forgiven for thinking that.
Yes.
I don't think I've got red. I've got black.
No, we have no red numbers on our...
No, I can understand why you're saying
Yeah.
that. If you look, if you once find the page on the screen,
Yes.
what we would call the electronic numbers are shown in red.
They are shown in red, yes.
Whereas the ones on the hard copies are in black. They're different.
Isn't that wonderful? What a lovely life we lead.
Whilst it's very kind to produce a transcript, I just wonder whether an index with the electronic numbers on it might not do just
Yes, we will do whatever we can to help the board to get the
You
references.
said black 280, that ends court rise. Is that the page you're wanting to refer to?
Have you found it electronically? No.
Yes, it's the conclusion of the passage, black 187, red 280, where the papers have been put to him, and at the top of the page 280 he refers to the Ingram article.
It's red 280, sorry.
Red 280.
Black.
Red 280.
Black 187.
Thank you, Dad.
One
Is it?
Yes, it is, my lady. Yes.
So thank you.
Got it.
And the point was made that in that paper there was no significant increase in complications. The patients that were operated on within the 12-hour window, as opposed to those that were operated in the 12 to 24. And he was asked whether he agreed with that, and he said, well, yes, it does, but it's not all right to suggest that you wait for 11 to 12 hours, but that's not the point. The point relates to causation and not to breach. And as we will
Can you remind, I'm awfully sorry, I know I ought to know, are those perforation patients or all patients?
General acute abdominal patients, so it will include a range.
All appendicitis is, or most of it is acute, isn't it?
Yes, but probably other acute abdominal conditions as well.
Right. Yes, I see.
But it was a very large study, some 33,000 odd if my memory serves me right. The third point is that Dr.
What was the second point?
Sorry.
What was the second?
Oh, well, the first point was not appropriate to challenge. Second point was it was in fact challenged.
Oh, whoops.
I beg your pardon. My numbering.
Right.
Third is Dr. Okareke's statement, which is at 423, that's red, 330, black. Paragraph 6. 2 points. One, it was busy. He phoned and they were very busy. And the second is that he was not in danger, was the clinical assessment, and could await the outcome of the CT scan. And the fourth point is that Dr. Lightman agreed with that assessment, and the page reference is 268, red, line 15, black 175, to page 270, red, line 25, 177, black. If one turns finally to the transcript of argument at page 364 to 367, red, (270 to 274) black, one can see the discussion between the judge, who explicitly raised the causation point. It's line 16. Judge expressly wanting help about causation. If it had probably started before he got to surgery, difficult for me to be satisfied when he got to surgery that probably anything would have turned out much better. Refers to Dr. Lightman and Conn saying that, rupture, not an explosion. The judge said, yes, but can you say it would have made a difference? Because that's the question.
Can you say that it would have made a difference? Isn't it? He's drawing attention to the owner's point.
Yes, and we don't know, is the answer. And then the court brings him back to that. We'll pause there because this is quite important. Given that the burden of proof is on you, if we don't know, am I not obliged to decide the case in favour of the defendant? Massive rowing back from Mr. Packeye, no, not at all. Then an attempt to recalibrate time for the following page. And it concludes at page 367, at the top of the first 3 lines, that his argument is the surgery would have prevented the perforation and the whole host of other problems. That was the case they were running. And so, with respect, in the light of the judge's analysis and findings, we submit that it would not be appropriate for this court to seek to make yet more alternative findings on the basis of the material that is before the court. So that's our submission on the facts. If the judge got it wrong, then it has to go back. Very briefly, if I may, the McGee point. It may be said that McGee didn't decide anything other than you just draw inferences from the facts. from what facts you have, and it didn't decide any new principle of law. If that is submitted, we respectfully submit that's wrong. We know from the exegesis of McGee in Fairchild and Barker that it is a pure risk case.
A
Pure risk case. In other words, all that McGee could show was an increase in risk.
And so he ought to have failed.
Well, so it's a precursor to the Fairchild enclave. It is not a case which you can use to say you're allowed to draw factual inferences, because McGee wasn't that case. And this has arisen in the case of Hennigan, which reference to Hennigan is volume 2, tab 23. Page 1614, I'm told, hopefully maybe your page numbering.
So this is
Hennigan,
Hennigan, volume 3.
in volume 2,
Volume 2, I do apologise.
tab 23.
Tab 23, right, yes. That is
What's my
1614.
suggested one number?
1614. You've cracked it.
Finally, just before I'm about to sit down. Hennigan was an asbestos and lung cancer case. It was agreed that the total occupational exposure, agreed by the medical experts, total occupational exposure did cause asbestos. What the claimant tried to run was a McGee-type argument to do with apportionment between defendants. Beg your pardon, well, I say McGee, a McGee/Bonington. What they tried to argue was that Bonington survives outside of, beg your pardon, McGee survives outside of the Fairchild enclave. So there are some cases in the common law, it was said, where you can have a material increase in risk which doesn't meet Fairchild conditions and which allows you nevertheless to recover on a full basis. So not quite Bonington because you couldn't prove the factual link, not quite Fairchild, but something in between. That was rejected by Mr. Justice J in Hennigan, and the I can find the page, the relevant paragraph. It's towards the end of the judgment. It's paragraph 55.
Page.
1627. In my judgment, no intermediate category of the kind Mr. Allen is seeking to identify. There are only two categories. First category embodies conventional approach. Second category entails the application of principles laid down in Fairchild. Bounds of the second category need to be defined for the purposes of this case, because it was lung cancer, not mesothelioma. Once a case properly falls within it, the claim succeeds if proof of an enhancement of the risk is made out on the balance of probabilities. Thus, for the purposes of the first category, proof of damage in whole or in part is required, whereas for the purposes of the second, proof of enhancement of risk of damage is required. Mr. Allen's intermediate category does not exist, or is in fact the same as the second category. That is the case which is on its way to the Court of Appeal, and quite possibly elsewhere, because it extends Fairchild to lung cancer. Unless the board has any questions,
I think you've been asked quite enough questions in the course of the morning.
Well, I hope my answers have been helpful, my lady. In that case, may I invite my junior to follow to deal with comparative?
My lords and lady,
Wyszyński.
I'd just like to briefly turn your attention to what we say are the most useful cases from comparative law jurisdictions on the material contribution to injury test. The first case is Clements and Clements, which is at volume 1, tab 13, page 1213.
From Canada, by the looks of things.
From Canada. It's a Supreme Court of Canada case from 2012 and is the latest senior court decision from Canada to examine this issue. It is useful because it deals with all the Canadian cases on material contribution to injury, including Snell and Farrell, and also contains an exploration of what the material contribution test is.
Sorry, volume what?
Volume 1, my lord, tab 13. This was a road traffic case where an accident occurred due to a number of natural factors. The road being wet, a nail being present on the road, causing a deflation of a tyre, and some negligent factors were potentially implicated as well, namely speeding on the part of the driver and overloading of the motorbike. The causation issue at trial was whether, but for the negligent speeding of the driver and the overloading of the motorbike, the accident would have been prevented. The defendant driver called evidence on that issue to the effect that the accident would have happened anyway as a result of non-tortious causes. And that evidence was rejected by the trial judge. At paragraph 3 of the Supreme Court decision, which is at page 1216, it is recorded that the trial judge could not make a determination on the ordinary but-for basis. He couldn't decide on the evidence whether the accident would or would not have happened without the tortious factors, but decided the case in the claimant's favour on the material contribution to injury basis. So this is a useful and rather rare case from the comparative law jurisdictions where a decision was in fact made and turned on the material contribution test. The case went up to the Supreme Court on the basis that the material contribution test was not applicable and could not avail the claimant. And that argument was accepted by the Supreme Court. The defendant was found not to be liable on the material contribution basis, and the case remitted to be retried on a but-for basis. The most useful paragraphs are firstly paragraph 28, which notes that no cases in Canada have been actually decided and found for the claimant in the end on the material contribution test, and that is page 1237.
Which numbers, of course, are not on anybody's hard copy, I think.
My lady, no, that would be far too useful. There, at paragraph 34, Justice McLachlan notes that a previous Supreme Court of Canada case called Resurface, which is in the bundles, but I was not intending to draw you to, the earlier case of Resurface had suggested that if it was impossible for either side to demonstrate on the evidence what would have happened but for tortious factors, a claimant might be able to succeed on the material contribution basis. And the Supreme Court says at paragraph 34 that that is not a complete statement of the law, and that alone does not bring a case within any exception to the but-for test.
When they were speaking of material contribution,
Yes.
were they speaking of material contribution to injury or material contribution to risk, or were they using those interchangeably?
Well, they keep on referring to risk.
They do.
Yes. My Lord, at paragraph 15, Chief Justice McLachlan explores that precise point. And he says, she, I apologise, my lords and my lady.
Well, she is probably the most famous female judge in the world, so with the possible exception of Ruth Bader Ginsburg. So I think it's necessary to make the point.
My lords and ladies,
So paragraph 15.
Paragraph 15.
Risk.
Yeah.
She says that material contribution to injury is a misnomer because if you have not been able to show that you haven't actually caused on the but-for basis the injury, what you are saying that you're able to show in terms of the outcome is an increase in the risk. And that may well be as a result of your contribution to a process, in our case sepsis, that has ultimately resulted in an injury. But looking at it from the perspective of your causal effect on the injury itself, it can only be said, if you haven't proven on a but-for basis, that you've increased the risk. At paragraphs 35 to 38, Chief Justice McLachlan examines the issue of whether impossibility of proof on the but-for test is sufficient to take a case outside the but-for test and to relax the test to a material contribution one. And she decides that that is insufficient. She makes a very similar point to one made by Lord Hoffman in Gregg and Scott, where she explains that impossibility simply means that on the evidence before the court in that particular trial, the evidence has not been able to establish a but-for cause. But that there is no such thing as impossibility in logic and ultimately. And that if impossibility was sufficient to take a case outside the usual requirement of the but-for test, then that would constitute a serious breach of causal requirements, and it would enable plaintiffs to not gather the evidence that they need on the but-for test, come to court and say, I don't know what would have happened, and to succeed. In the rest of the judgment, and paragraph 45 is just one example, Chief Justice McLachlan states that the exception to the but-for test, where a material contribution test can allow a claimant to succeed, is where multiple tortious actors have caused the injury. And that is the Cook and Lewis, 2 hunters shooting in a forest point. So she narrows the applicability of this lower test to that situation, which does not apply on our facts. The Court of Appeal of New Zealand has considered the material contribution test recently in the case of Ambrose, which is at volume 1, tab 1.
Are you going to give me a page number?
My name, that is, I'm certainly attempting to.
Well, the advantage of armband is it's 1.
The page number is 911, my lady.
It is too. Something's beginning to work.
This was a clinical negligence case where a lady died in hospital.
Ah, and the court has 2 women judges on it.
My lady, I was entirely aware of that, I assure you. The plaintiff was not able to demonstrate at trial that but for the doctor's negligence, Miss Ambrose would not have died. And the High Court used a lower test, which is set out at paragraph 4 of the judgment, to decide the case, nevertheless in the plaintiff's favour. Once the case came to the Court of Appeal, the test proposed is set out at paragraph 9. And that is essentially a presumption test that if in a clinical context an injury occurs, which was precisely the type that the treatment was intended to prevent, and the injury fell within that, then the prima facie position is that causation is established.
Is clinical negligence an exception to the general personal injury compensation scheme in New Zealand?
It is not, as I understand it, my lady. No, this was a case.
This is in the context of the accident.
Yes.
Well,
this
that's
was
what I
brought
thought,
in.
yes.
But
Yes.
it seems to proceed on the basis, if you look at the first line of paragraph 4, causal nexus is nevertheless necessary.
Yes. My lord, precisely.
Yes.
But it's causal nexus between...
The conduct.
I could say between injury and what? If you don't have to prove negligence, it's causal nexus between injury and what? Or rather, what an injury?
The medical error it speaks of.
Certainly, there was a fault and a breach element.
Yes, but that's not required by the New Zealand scheme.
Well,
That's why we're asking these questions.
my lady, yes.
Unless there is a special requirement in certain contexts.
Certainly in this case, there was a finding of fault.
Error and the injury. The error doesn't have to be negligent.
That's at paragraph 98. That is set out. So from paragraphs 98 sets out the errors that Dr. Hart had made. And at paragraph 100 sets out that in the High Court's view, there was a possibility that the death could have been averted had she been monitored more carefully. From paragraph 102, it is also clear that the court was faced in deciding at the bottom of that page, either she died as a result of her underlying condition or she died as a result of medical error by a failure to diagnose, monitor and treat her appropriately. In order to succeed, Mr. Ambrose is required to prove the latter on the balance of probabilities.
Yes.
So it does seem that
Yes.
the same...
There would obviously have to be something, because otherwise everybody who died in hospital, at least, or under medical care, would have a claim. So there has to be something.
I think we see the summary in paragraph 2.
That's right. It says medical error or medical mishap.
Yes, he sought cover under the then compensation legislation. Medical error mishap, yes.
My lords, yes. If memory serves me right, the accident compensation legislation has a statutory provision entitling somebody to fall within the scheme if medical error was the cause.
Well,
Hence-
paragraph 2 seems to suggest that that is the case, and it makes sense. But it's not the same as having to prove negligence.
My lady, yes, but in our submission, the analysis of the causal link applies whether there is a different standard or not on page. The court, in deciding whether a lower test of causation is applicable, undertook a review of the case law beginning at paragraph 26.
Page. See, the whole purpose of this is that I can then punch these numbers in and go straight there.
My lady, it is page
99.
920.
Thank you.
At paragraph 26, it is stated that there have been a number of situations where dissatisfaction with the result has led to calls for a modification of the but-for stage of the inquiry. And then comes an interesting sentence: the challenges to the traditional test can be placed into 3 categories: industrial diseases, loss of a chance, and informed consent. So this judgment analyses the material contribution test under the industrial diseases category. And indeed, the classic case law on material contribution to injury, namely Bonington and McGee, is of course an industrial disease context. At paragraph 36, which is at page 924, after having analysed the material contribution test under that heading, it is noted that the view has been expressed that this line of cases is limited to industrial diseases, although a definitive position is not taken on that point. But it certainly suggests that that court saw the material contribution line of authority as at the very least principally an industrial diseases applicable test. And the crux of the decision comes at paragraph 80, which...
Paragraph what?
Paragraph 80, which is on page 941.
Thank you.
Where the Court of Appeal comes to the conclusion that we do not consider that the scheme of the legislation would allow a presumption of causation to arise in circumstances where the evidence would not, without the presumption, reach the required standard for proving causation. And over the page, at paragraph 82, the Court of Appeal states that Mr. Gray's test would thus pass the burden of uncertainty onto the corporation rather than the claimant, a position incompatible with Atkinson, where a reverse onus was rejected and where a risk that the injury was caused was deemed insufficient to prove causation. And what we say is that if a but-for finding cannot be made, in the usual way. To allow the claimant to succeed under the lower material contribution test would likewise pass the burden of uncertainty onto the defendant. And that result has been rejected in New Zealand.
And what reason do they give for that? Is there some sort of jolly unfair reason, or?
It's, the reason is one on authority. The case which was taken to be the leading authority on this area was Atkinson, and it was considered that to depart from that and to allow a claimant to succeed would fall foul of that.
But am I right, this isn't an application of Bonington and Wardlaw. It's an entirely different test of causation set out in paragraph 4 of the of the judgment.
My
The
Lord,
finding
yes.
of fact, which is at 86, paragraph 86, was the High Court found that Mrs. Ambre's death was only possibly avoidable.
My Lord, yes, and
That wouldn't meet Bonington and Wardlaw anyway, would it?
well,
Would it?
my Lord, the general point that allow the material contribution test passes the burden of uncertainty onto
I
the
understand
defendant
that.
is the same.
Yes, I understand that.
And of course, in our case, the trial judge said in terms, I can only find that the negligent delay may have caused the injury, but not would have done. Whether the burden of uncertainty is passed by a reverse onus test or a lower material contribution test where you cannot meet your ordinary onus to show but for causation, the result would be the same via perhaps slightly different legal reasoning, ultimately to pass the burden of uncertainty of causation onto the defendant, and that's the outcome which is rejected. The position in the US is stated in the US restatement at volume 6, tab 70. That is page 3199. My lords and lady, the rule that applies in the US on factual cause is set out at that page. The language of material contribution in those precise terms does not appear in the US case law, but a lower test of causation has been advocated by certain parties, and it seems to have found its way towards substantial factor rather than material contribution. And I would invite my lords and lady to read the part of the restatement that deals with the substantial factor test. The analysis begins at page 3206.
And the other page number?
Is that 2126, the hard copy number?
Yes, it is 2126 in the hard copy.
Yes, it is.
The hard copy is the references I have, so if I can give those to my lords and lady, that would be very useful. The analysis is at pages 2126 to 2127, and then at 2138. And the substantial factor test is argued in the restatement to not be useful and to be wrong insofar as it implies that a claimant can get home on anything less than but for. And also, lady, unless I can be of any further assistance, those are my submissions.
Well, to what extent is the restatement representative of the law of each of the 51 jurisdictions in the United States?
Well, my lords and lady, as I understand it, it is the most comprehensive attempt to explain the law in the US. it is very frequently cited by the courts, and one of the cases that we do have in our bundle from the US is the case of Paroline, which is at volume 4, tab 38. It is an interesting case where a victim of crime has been caused psychiatric injury through the combined viewing of pornographic images of her by thousands of people, and therefore but for causation cannot be made out against the defendant in that case for the purposes of a criminal restitution statute that would allow money to be paid to the claimant. But that case sets out an analysis of tort law, even though it is a criminal restitution context. And the but-for test is discussed throughout that case as being the test of causation. And the US restatement is referred to on numerous occasions by the US Supreme Court, by the majority judgment. So it does seem to be an authoritative statement of the law in the US. And in that case of Paroline, the exception to but for is limited to multiple wrongdoer scenarios as well. And in that sense is very similar to the Canadian position of the Cook and Lewis to Hunter's situation, allowing you to escape the but-for test, but not otherwise. And the hard copy reference to the relevant page is 1401. Ladies, thank you.
Thank you very much indeed. Yes, sir.
Lords, there are, of course, numerous interesting questions of law which arise in this appeal. But as one of the board observed this morning, Mr. Kamal Williams' interests, of course, are simply in maintaining the judgment he obtained in the Court of Appeal in Bermuda. We respectfully submit that before one comes to those questions of law, it's entirely apparent that he's entitled to succeed on the facts on one of two alternative bases. The first is that the judge proceeded on the basis that Dr. Lightman was saying that the operation should have been carried out within 4 hours of the CT scan. Regrettably, in saying that, he appears to have misinterpreted the evidence of Dr. Lightman. Take the court, if I may, and I hope this is the right reference, to page 185, line 22, to 186, line
I think it's
22.
clear he'd actually said within 4 hours from arrival at the emergency department.
As your lordship observed this morning, yes. It's 4 hours from admission. And that's what the evidence shows at page 186. That, of course, with an admission at 11:15, takes one, on his view, to an operation at 13:15. As my learned friend Ms. Harrison has submitted, I think principally this afternoon, there was some cross-examination as to that, and that, of course, is right. But the cross-examination was proceeding not upon the basis that it shouldn't have been 4 hours, but it should have been 5 hours or 6 hours or 7 hours, but that it would have been acceptable for there to be a very much longer period. And quite clearly, with respect, the judge has rejected that suggestion, because what he's done is to start from the 4-hour period for which Dr. Lightman contended. I say in parenthesis, if I may, as the court observed this morning. In fact, in his report, he was saying 2 to 4 hours of admission, but say 4 hours, which is where the evidence, I think, arrived at, and was extending on that 4-hour period. So that if the judge was right, the 4-hour period, if Dr. Lightman had been correct, the 4-hour period was leading to an operation at 15:15. The judge extended that period to 16:15 or 17:15, and I'll come back to that. That extension, of course, was rejected by the Court of Appeal as being pure speculation. They say a shorter period would have been appropriate. But we respectfully submit that if the rejection of the extension of the 4-hour period is appropriate, as we submit it would be, you end up with an operation at 15:15, and as the judge found, the perforation, the rupture began to occur, this is judgment page 110, paragraph 143, at 1519. And even on my learned friend Miss Harrison's case, if the operation is performed before the rupture, then there can be no question that but-for causation in its conventional form is established. So we respectfully submit that when one comes to look at the evidence which underlay the judge's conclusions, when one expunges from those conclusions the extra hour or two for the reasons expressed by the Court of Appeal, one comes to a conclusion that the plaintiff should have succeeded simply upon that basis. But perhaps more powerfully, this is, we respectfully submit, a case where it's quite obvious that the robust and pragmatic approach to but-for causation advocated amongst others by my Lord Toulson in the Drake case self-evidently should be employed. It may be that the Bermudian Court of Appeal was in fact employing that approach. When it talked of material contribution, it was actually talking of material contribution to but-for causation. I'll come to that submission, if I may, in rather greater detail in due course. I see my Lord Hughes looking puzzled. Perhaps I'll come to it now.
Well, I often am.
Well, it always leads one to believe that one's just made a bad point. Can I see?
Come to it when you want to come to it.
I'm grateful. For reasons to which I'll come in due course, I'm grateful for the lifeline. It may well be that that is in fact the basis upon which the Bermudian Court of Appeal arrived at the conclusion. But if it was not, we respectfully submit, this is quite clearly a case where the court should have been drawing inferences which would have led it to conclude that but-for causation had in fact been established, even if the primary evidence did not establish that fact. The starting point for that submission.
Now, you said that you should succeed on the facts on one of two alternative bases.
Yes.
I think you've explained basis one.
This is basis two, my lady. This is what I was calling the robust and pragmatic adoption of the but-for causation.
Basis one is that the operation should have preceded the rupture. Basis two, it shouldn't have, but a robust approach to causation gives the same result.
Yes, exactly, my lord. Yes, I'm sorry, I'm not making myself clear. The primary cause, and this is a question my Lord Hodge raised this morning, the evidence in relation to the primary importance, if I can put it like that, of the sepsis is summarised in our written case at paragraph 24. As Mr. Williams' treating cardiologist, this is Dr. Levick, who was called in after the complications had supervened. As Mr. Williams' treating cardiologist, my overall clinical impression was that the primary cause of Mr. Williams' cardiac event and ARDS was due to the onset of sepsis arising from the rupture of his appendix and subsequent peritonitis. So there is the evidence of the treating doctor, obviously a servant of...
This is paragraph 11 of his written statement.
Yes, indeed it is.
This is Mr. Levick.
This is Mr. Levick, the cardiologist. It's adopted within the evidence by Dr. Zusman, expert witness on behalf of the defendant at page 519, who agreed with that view. So it's not just Dr. Levick, the treating doctor, who put forward that proposition, but it appears to have been adopted by the cardiologist called on behalf of the defendant. Even if the 6 hours from admission point is correct, in other words, if one takes the judge's starting point, the judge's period, if I can put it like that, but the correct starting point, obviously you're coming to an operation at 17:15. It's 6 hours beyond 11:15. The question that then arises, of course, is, well, what would his condition have been had he been operated at 17:15 and not at the time in which he was, in fact, operated? And there are, we respectfully submit, 2 clear pieces of evidence which answer that question. The first is to be found in the bundle at page 228 to 229.
Are we talking electronically here?
I hope I've got this is the primary trial bundle, but I understood it's what my learned friend would have called red 228. I hope and think that those are the same numbering as your ladyship has, but I'm rather a victim of this as well, if I'm wrong.
Yes.
Whose evidence is this you're looking at?
This is from the evidence of Dr. Lightman,
This is Dr.
Cross-examined by Mr. Doughty.
but no, this is in chief to Mr. Pachai.
Well, 228 is...
And now in terms of what you say here, that's how the page starts.
Yes,
That is 228.
that is 228.
Could you give us the other? Could you give everyone? Could everybody give everyone both numbers? I only have
I'm so
the
sorry.
black bundle.
It's black
numbers,
135.
no red bundles at
Well,
all.
that's...
I think it sounds like
two, thank you.
again, but black 135, red
135.
228. I'm so sorry.
That's all right. Thank you.
And he's being asked, as you'll recall, that the second doctor to assume care for Mr. Williams examined him at 1643, and Dr. Lightman is being asked what significance he believes that examination has. And at line 22 he says this, or the question is this: over the page is the 1643 physical examination we've seen, yes? Right. And this, just again to confirm that, says what to you? Answer that at that point in time there was a change in his condition, therefore a change in the physical examination which would indicate a progression of his appendicitis with some evidence of perforation. As you say, I think you put it, or his lordship put it, it's starting. It's starting. So that going back to the balloon bursting point that I think my Lord Tolson made this morning, one can see that what Dr. Lightman is saying at that point is that you may have the start of the rupture at 1519, and we don't seek to go behind the judge's point at that, but that the actual leakage from the rupture and the start of physical appearances consequent upon that leakage is starting at 1643.
Well, has started by.
Has started by, yes. But at that point, in relation to the physical examination, I can take your lordship to the evidence, but it's clear that the claimant is not screaming, he's not in substantial pain, there are no serious physical symptoms to be discovered. More important, perhaps, is the evidence at this point in relation to the CTG, because the CTG, as the court will recall, was actually taken at 1715. And the evidence in relation to that is to be found at page 213, red, which is 120, black, going to 215, 28, in the same bundle. And there one has the radiological examination starting at line 17. Perhaps I would start at 14, the question. And can you help us the understanding in this context of your evidence? Why is that the case? Because I'm so sorry, I should have started a little earlier. Question at 8. Perhaps you can clarify this for us, which arises, Mr. Lightman, Dr. Lightman. The CT scan, if I'm correct, identified the diagnosis of acute appendicitis, but it does actually say no rupture. It does say that the appendix is not perforated, yes. And can you help us to understand, in the context of your evidence, why that's the case? There are specific findings that a radiologist would need to see in order to make a diagnosis of perforation. They would need to see either that they refer to as what they refer to as free air not within the confines of the intestinal wall, but air in the cavity of the abdomen. They would need to see that the orally ingested contrast had leaked out and was in the abdominal cavity. They would also need to see evidence of free fluid. Those three things suggest perforation. And this radiologist in this test did not demonstrate that according to the report. Reading on, can we just run back over those three things? I think I can jump on because he simply reiterates them. Going to page 215.
215 black or red?
Red, my lord, 122 black, and simply running on in the same excerpt, if I may. Question, now if the process is beginning at 443 and the CT scan, CAT scan is done at 5:15 and not read until 7:38, right? How do you relate the issue of perforation as against the reading from the CT scan? Well, clearly that 2 hours, or 2 hours and 20 minutes, whatever it happened to be, would allow sufficient time for the condition to continue to progress. And certainly that is consistent with what happened here, from a clinical standpoint as well, that the heart rate continued to rise, and Mr. Williams' continued condition appeared to progress to the point where he did have evidence of a perforation. So he's showing signs at 4:43, 4:45, half an hour later the CT scan is done, right? And it's that CT scan that's being read 2.5 hours later. Yes, right. And during that time, your evidence is that his condition is obviously deteriorating. It is. So there's clear evidence of deterioration in the following 2 hours, from 17:15 through to 19:15 or so, when the CT scan is interpreted. There is, we respectfully submit, too, substantial evidence to demonstrate that there is further progression in the condition. Beyond that, I should say, just pausing for a moment, if I may, for your note, that Dr. Conn, the expert on behalf of the BHB, agreed that there was no CT perforation. I don't take you to it, but that's red 285, lines 20 to 25, and that is black 192, lines 20 to 25.
So no perforation seen on the CT scan?
No perforation seen on the CT scan, agreed by Dr. Conn. What was the condition at 21:30? Well, by that time, Dr. Conn was agreeing that there was substantial pus and phlegm. As the court will recall, I could probably put this generally, he was saying that there was so much as described that it must have been building up over very many hours. That's a suggestion rejected by the judge, of course, who says 4 to 5 hours would be enough. But on any view, we respectfully submit, the evidence demonstrates very little evidence of leakage consequent upon perforation at 16:43 clinically. Very little evidence of leakage consequent upon perforation on scanning at 17:15. Dr. Lightman saying there would be progression between 17:15 and the time of the reading, which is about 2 hours later. And Dr. Conn, by the time of the operation at 21:30, saying that the leakage was, the build-up of pus was so bad that it must have been going on, I think, at least 12 hours was his suggestion, but his preferred timescale was much longer. He was saying that the perforation must have occurred very substantially before Mr. Williams was admitted to hospital, so substantially before 11:15, obviously. So we respectfully submit that when one asks the question, was the judge entitled to infer, to make a robust inference, that there must have been a substantial build-up of pus between the time at which, the latest time at which the operation should have occurred, 17:15, and the time of the surgery, 4 and a bit hours later. And one bears in mind the, I think, undisputed evidence that the perforation is not like bursting a balloon. You end up with a progressive development, which of course would be relevant with, consistent with the evidence I've just been describing. One is left, we respectfully submit, in the position of saying, well, it's very difficult to see upon what basis a but-for inference would not be drawn that the build-up of the sepsis would be such as to cause the cardiac complications and so on by the time the operation occurred. Put it the other way, if I may, for a moment, it would, of course, have been open to the hospital board to call evidence to show that in this sort of situation, without the sepsis, without developed sepsis, or with some sepsis, whatever they chose, the risk of a cardiac problem was high in a young man of this sort. They could have called evidence to show that this is a Wilshire case. There are a whole series of different potential causes, and you can't simply choose between them. But we respectfully submit that on the evidence that was actually available in the case, without calling that evidence, the judge should have been driven to the conclusion that there was an inference to be drawn here. And the difficulty is that, and it's the passage that the learned friend Ms. Harrison took you to shortly after the short adjournment, that he appears to have proceeded upon the basis, I can see it from the judgment, he appears to have proceeded upon the basis that unless there was clear scientific evidence to show that the relevant delay caused the injury on a but-for basis, he was bound to find for the defendant. And if I could take you back to the judgment, I think one can see that from the relevant part of the judgment, in that he says, at page 144, red 48, I think, black.
Paragraph?
Paragraph 113, my lord.
That's 51 black, I think.
51 black.
50. Oh dear. Yeah. I'm so sorry. 51 black, apparently, 113. I accept Dr. Levick's opinion that Mr. Williams' heart experienced a significant amount of stress caused by sepsis. From this, I understand the complications Mr. Williams experienced were probably the result of a combination of surgery sepsis. Thus, it was too simplistic for me to find that, even if it had been operated upon earlier, Mr. Williams would not have developed complications until after 2130. So, we submit that it's reasonably apparent from that passage and from the passage at page 364, red 271 black, to which my own friend Ms. Harrison took you a little earlier, that the judge simply has not asked himself the robust, pragmatic application of but-for causation, the reasonable inference question, but that had he done so, then he must have concluded that the appropriate inference was that without the guilty delay, the cardiac complications would have been avoided. So we respectfully submit as a starting point on behalf of Mr. Williams that this case, turning as it does on those facts, should have succeeded on his...
The Court of Appeal didn't put it quite like that, did they?
Well, my lord, can I come to that? Because I have ventured to submit that they may have. Can I seek to make...
Follow from that, they may not have it.
Well, it's a little difficult to know. But look, can I make a general submission to start off with before coming to that? One of the problems we respectfully submit in this area is the words material contribution are used in a whole series of different contexts. So that in one context, they're used as being, for, if I can put it like this, the eggshell skull case. You can say, well, Athos is one of the cases in the papers. 2 car accidents followed by a spinal injury when simply carrying out a stretch. Without the stretch, the spinal injury, the disc herniation, would probably not have occurred, but the court was concluding that effectively the earlier accidents had set up had so damaged the back that was why the herniation occurred as it did. That's one context in which it's used. It's, as I say, the eggshell skull, eggshell spine, whatever it is. The second context in which it's used is the Bonington colliery context, the Bonington context. And in that context, we respectfully submit that it appears to be being used upon the basis that it is possible to infer that there was a material contribution, so that to at least a part of the damage, and in those circumstances, there has been material contribution. The third context, of course...
So that is genuine but-for causation, but you just don't know which bit.
Yes,
It's not material contribution to part of the damage, it's a cause of part of the damage,
yes,
but a material contribution to the whole.
Well, Lord, yes, we accept that. And we respectfully submit that when one comes to look at Bonington, it's basically Bonington as an inference case. You're entitled to infer that it has caused a part of the damage, not all of it, but because it's caused a part of the damage and because it's indivisible or because it's not contested that there is full recovery, there is recovery in those circumstances. The third, and of course most controversial, is the Fairchild context. And certainly a part of the appellant's case here appears to proceed upon the basis that the Bermudian Court of Appeal was adopting the Fairchild approach. But we submit that on analysis one can see quite clearly that they're not. I have to accept immediately in parenthesis, it's not quite clear which of the first two they are adopting, but that's why I say it may well be that they are in fact adopting the robust inference of fact approach.
It's not entirely obvious why the Court of Appeal mentioned Fairchild at all.
No, my Lord,
On your analysis,
Because on
why do
any
they mention
view-
it at all? Yeah?
On any view, we're not in that enclave.
well, not, indeed, I think, if I may say so, one can probably see that they mention Fairchild so as to dismiss it. May I take you to the relevant passages of the judgment?
I mean, you're not saying it's within the Fairchild enclave, even on your most remote alternative case. Are you?
On my most optimistic case, my Lord, I think I would be pushed to say we find ourselves in what I think my Lady Hale called the Fairchild box. and I don't do so, and I hope that's entirely clear from our written case. May I turn then to the judgment of the Court of Appeal? It's red 158, black 50, well, I think it's 65, but
58.
58 to start.
Which bit are you going to? Paragraph
I'm going to go to paragraph 36, my Lord, if I may.
65.
65 is right.
Yes, I'm so sorry. I've got a whole series of different numbers on here as well as the red ones, and it's difficult to know where everyone is. Can I come to maybe as well to pick it up at 35. In his report of 7th December, Dr. Lightman expressed the view that negligent delay was the cause of the complications suffered by the patient. However, in paragraphs 114 and 116 of his judgment, the learned judge did not embrace that firm conclusion, but expressed uncertainty as to the cause of the complications and went on to hold, therefore, that the appellant had not proved his case. As regards that finding, we hold that the learned judge was in error by raising the bar unattainably high. Obviously, respectfully adopt those words. The proper test of causation was not whether the negligent delay and inadequate system caused the injury to the appellant, but rather whether the breaches of duty by BHB contributed materially to the injury. That those breaches did contribute is beyond argument. Originally, where causation was alleged, it was for the claimant to establish that the defendant owed him a duty of care, the defendant was in breach of that duty, and the breach of that duty caused the damage or loss, and gypsum is dealt with. More recently, the boundaries of tortious liability have been expanded, and as explained in Clark and Linsell on torts, the but-for test is sometimes relaxed to enable a claimant to overcome the causation hurdle when it might otherwise have seemed unjust to require the claimant to prove the impossible. It was described in Barker and Chorus, quoting from Fairchild and Glenhaven, as a different and less stringent test of causation. In Fairchild, a defendant who had created a material risk of mesothelioma, a disease contracted from inhaling dust from asbestos fibres, was deemed to have caused or materially contributed to the contraction of the disease. In Bailey, the but-for rule was modified, and the correct question was whether the negligence had caused or materially contributed to the injury, and if but for the contribution of the tortious injury, the injury would probably not have occurred. The claimant would have discharged the burden of proof. Pausing there, that appears to be interpreting Bailey as a but-for causation case, and obviously I'll come back to that in due course.
Does it?
Well, my Lord,
Well, it seems to be saying two different things.
It does.
well, I think I probably better respectfully adopt my Lady Hale's comment. It probably is saying two different things. It may be saying but for, it may be saying, as it were, Bonington Material Corporation.
No, but you see,
Material
look at
Corporation.
36, which you read kindly.
Yeah.
Is that not contrasting the question, did the negligence cause the injury, with did it contribute materially to it? Whereas your contention is that, as I understand it, that material contribution to the injury is another way of saying, is a cause of the injury. But here they're being contrasted, aren't they?
But Lord, the difficulty we would respectfully submit with the whole of the judgment is it's actually quite difficult to see what the Court of Appeal in Bermuda thought they were doing, with great respect to them. And I can see exactly why your Lordship makes that comment at that point. But again, when one comes, can I come to the end of the excerpt and then come back to that question? Paragraph 40. Counsel for the BHB referred to Gregg and Scott, which was a claim for damages for loss of expectation of life, which there was a wrong diagnosis of a lump under an arm, so out of which treatment was delayed for 9 months, the chance for cure reduced from 42 to 25%. Held by a majority, there was not a sufficient causal connection between the defendant's contact and the claimant's injury. But there were two dissenting opinions, and two statements by Lord Hoffman are instructive, namely that for loss to be recoverable, it must be shown that the damage in question was attributable to the defendant's wrongful act, and there must be a sufficient causal link between the defendant's contact and the claimant's injury. In that case, as the board will recall, Lord Hoffman formed one of the majority, and he was, it's not a bad summary of what he was saying. They don't identify which passages he was referring to, but we can see that by looking at the passages referred to by the respondent in the appeal, the appellant here, the hospital board, it was those passages where Lord Hoffman was saying that Fairchild cannot be applied in circumstances such as this. I can take you to that, demonstrate it, but it is quite clear we submit. 41, it is no longer a question of all or nothing, but one of sufficiency. 42, in my view, in the case at bar, causal or causative links between the inordinate delays coupled with the defective system, which together contribute to the appellant's injury, were clearly established. Well,
Yeah, but how?
Well, quite. if I may say so, that is exactly the problem. Because if one looks back at paragraph 36, they start by saying, as regards that finding, we hold that the learned judge was in error by raising the bar unattainably high. Well, as I've already submitted, it would appear from the learned judge's approach that he didn't consider the question of inferences to be drawn from the evidence at all. He simply looked to see whether there was direct evidence to show that the delay caused the heart attack. He didn't consider whether, on his findings of fact, it would be appropriate to infer that such delay caused such exacerbation of the sepsis that it should be concluded that that was one of the causes of the heart attack. And we respectfully submit, obviously, that's the approach he should, or one of the approaches he should have adopted. And when one comes on, of course I accept my Lord Hugh's point that it's not very easy to discern what is being said at paragraph 36. But certainly when one links paragraph 36 to 42, one can see, we respectfully submit, that whilst it's by no means clear I've made that point, it could well be that what they're saying is that the learned judge, in requiring scientific evidence where no scientific evidence could be adduced, to show, well, we think we've tried it on all these people having these delays, and as long as you don't delay for more than 6 hours, you don't get cardiac complications. If you do delay for more than that, and so on. But it may well be that what the Court of Appeal has concluded is that this is a case where, if the bar is lowered, not in the Fairchild way, but in the way of saying, if you cannot prove scientific causation on direct evidence, it is appropriate then to consider the inferences that should appropriately be drawn. You can see that it should properly be inferred that this is a case where substantial causation is proved.
And that means, does it, that you are entitled to infer that the complications would not have occurred but for the...
Yes.
Yes.
And that, as your Lordship, I'm grateful. Yes, that is a but-for submission, if I can put it like that.
Yeah.
And as I've already submitted, this is one of the problems of material contribution being used in all these different contexts, because one doesn't really know whether that is what they're saying or whether they're saying we're actually applying Bonington, to which, of course, I'll come in a moment. But Either way, we respectfully submit.
So you say that anyway, leaving all that, what they meant, perhaps neither here nor there in a way.
Yes.
The question is, what is the correct conclusion on the basis of the materials available? And you say that on the basis of the robust conclusion in paragraph 35, the judge's conclusion in paragraph 35, then it's appropriate to draw the relevant inference to establish but-for causation.
Yes, we submit either that the judge has misinterpreted the evidence, and had he interpreted it correctly, the evidence clearly demonstrated but-for causation, or if he was left in a state of uncertainty on the evidence, it's quite clear he was entitled to draw the inferences using the robust and pragmatic approach, which we submit is the first port of call, if I can put it like that in these circumstances. And there was no need to go on to Bonington and any extended causation, concepts of causation that may arise so far as Bonington's concerned.
Well, one view is that the Court of Appeal are in a bit of a muddle.
Hardly my place to say so, my lord, but it could be clearer, especially after a reservation of some 4 months, as I think it was, between the end of argument and judgment. It is, we respectfully submit, well, as my Lord Hodge said, it's not quite clear why Fairchild's mentioned at all, but for the reasons I've submitted, it's quite clear that they are not finding liability on Fairchild because they've adverted clearly to Lord Hoffman's strictures within Gregg and Scott that Fairchild can't be extended to this area. So it must be either extended but-for causation, robust and pragmatic but-for causation in that sense, or alternatively...
Well, there's nothing extended about that, is there? But-for causation
it's robust.
Can be arrived at as a result of direct evidence or by drawing appropriate inferences from direct evidence. Can I ask you an irrelevant question, which has been puzzling me, it's got nothing whatever to do with it. Which, if any, of the members of the Court of Appeal were previously members of the Court of Appeal in England?
In England?
Yeah.
I think none.
None.
I can check. Well, I think... what?
Lord Justice Evans?
Yes.
But not Lord Justice...
Ah, I'm sorry.
No, Justice Appeal Ward is somebody different.
Thank
I
you
hadn't
very much.
realised it was the same Lord Justice Evans. I apologise.
It is the same, Justice Evans.
It is.
That's
I'm
what I
so
thought, but I
sorry.
didn't like to ask a leading question on it.
I didn't know that. Well,
Thank you very
of course,
much.
I readily accept that.
I don't say it's relevant to the outcome of the appeal.
So that's, if I may say so, is our starting point, that we don't need to resort to further causation arguments. We would respectfully submit, as we've set out in our written case, that in these difficult cases where there is no direct evidence one way or t'other so far as the but-for test is concerned, the first port of call, if I can put it like that, for the court is, as my Lord Toulson says in Drake, to consider whether there are, using a robust and pragmatic approach, one can draw inferences which enable one to answer the but-for causation case. That appears from our written case. I don't think I probably need to go back to
What do you
it.
want us to do, Mr.? What do you want us to do? Do you want us to hold that the Court of Appeal has drawn that inference and was entitled to, or do you want us to draw it?
My Lord, I invite your Lordship, I'm not deliberately intending to duck the questions. I fear
The first alternative is...
it's going to sound like it. I invite the Board either to conclude that the Court of Appeal in Bermuda has adopted the robust and pragmatic but-for approach to but-for causation, and
Despite
it's right.
everything they said that indicated they weren't doing that.
Despite those parts which suggest they may not have been related, I don't think I'd put it quite as high as that, with respect.
But relying on 42.
Yes. So, despite the fact that those areas which it looks as though they may not have been, or, if I may put it like this, I invite the Board to conclude that neither Mr. Justice Hellman, and I think it's quite clear in his case, has considered the robust and pragmatic approach to but-for causation. And if the Court of Appeal haven't decided on that basis, then quite clearly they haven't considered it either. And if that's correct, then and the board is persuaded that that is the appropriate approach as I've submitted by starting with the facts, then we respectfully submit that the board is in the position that the House of Lords found itself in the Montgomery case, where because the correct test has not been applied, the board should itself, Montgomery and Lanarkshire, I know it's a case familiar to a number of members of the board. I don't take you to it. It's volume 4, tab 35. I hope. What is the correct reference? 2339. 2339, I'm told. And I would respectfully remind the board that, of course, that is in fact what happened also in Bonington. Because Lord Reed held that the wrong test had been applied in Bonington. And so the House of Lords there also, I'll come back to Bonington in a moment, but I just may make the point in this context. The House of Lords was also holding there that it was going to have to re-examine the evidence because the wrong tests had been applied. There are also examples of this in Snell and Novartis and Grimsby. It's not an entirely unknown situation for an appellate tribunal to find itself considering the judgments below, concluding that they haven't actually grappled with the right problem, and therefore they need to look again at the evidence. So, Lord, in answer to Lordship's question, that is the approach we invite the board to adopt.
Well, on the other side to say that that's quite wrong approach, and we should remit it back to, I suppose, a judge in Bermuda to grapple with.
I think the board will be unsurprised to hear that I'm not instructed to invite that course on Mr. Williams' behalf. And indeed, we respectfully submit that it would be inappropriate here. One can see that there was for the reasons I've submitted already, I don't want to repeat myself, there is a substantial body of evidence from Dr. Lightman, both in his reports and in his evidence, upon which a court would be entitled to draw inferences if it was not entitled to find but-for causation as a matter of primary fact-finding. And if that's right, then we respectfully submit that there is really no point in remitting the case back to Mr. Justice Hellman, because this court is in just as good a position to determine whether or not appropriate inferences should be drawn as would be Mr. Justice Hellman or indeed any other junior judge within Bermuda. Proportionality of damages probably is not a relevant consideration, but were it to be one, I would, of course, remind the court of the amount at stake so far as this case is concerned. May I move on then?
We're talking Bermudan dollars here.
I beg your pardon?
We're talking about Bermudan dollars here.
We are, my lady. I think that... Would you look? Yes, I thought it was. It's a parity with the American dollar. Yes,
We were wondering that.
yes, no, it is. I'm sorry, I should have asked that before, but that was my understanding. May I move on then to having turned away from factual findings, turn away from inferences of fact, turn away from robust and pragmatic conclusions to which I submit the judge should have drawn, Court of Appeal may have drawn, and if no one has to date, this board should approach the case on that basis.
Can I just see whether I've got the pith of what you have been submitting? You were saying that on evidence which was either found or not disputed, and on which the board can therefore safely operate, it's plain that the board's negligence significantly increased the presence of the agent which directly caused the relevant sequelae. That is enough to give rise to a prima facie inference that it did indeed make a difference. It would be open to the defendants to rebut that inference. One's not talking here about shifting of legal burdens, but they could adduce evidence to show that there were features which made it wrong to draw such an inference, but there's an absence of such evidence.
Yes. And my Lord, I can go a little bit further in that, if I may say so, is the pith of that submission. And I respectfully adopt your Lordship's observations. But I can go a little bit further in that there was some evidence from Dr. Lightman as to the effects that delay would have. May I invite the Court's attention to page red 234. And it's black 141, is it? Yes, I hope it is 141, though my black numbering is not entirely reliable. This, of course, I accept immediately, is evidence which is given against the background of Dr. Lightman saying that the operation should have taken place by about 3:30. And so it, of course, is against the background of no perforation commencing at that point. But there is some evidence which we respectfully submit is relevant. May I pick it up at line 7? And that operation would have taken place within the hour, 3:30. Answer around 3:30. Question, with no perforation yet commencing. Answer, not based upon the records that I have, or if perforation were present, considerably less contamination than what was found. So would he have had what you describe as a simple appendectomy? Yes. Minimal surgery, remove it, out of the hospital, max 2 days, usually 2 days for somebody of his age. And again at 231, I'm sorry, jumping back a couple of pages, and this is 138, I hope, in the black. He describes I should perhaps start at 2:30. He's asked about workup and starting at 2:30, line 23. Is that a term of art? It must be. In establishing the diagnosis of appendicitis and its treatment, Mr. Williams suffered from perforation, peritonitis, sepsis, heart attack and ARDS requiring intensive care life support and 14-day hospital stay. Oh, sorry, my apologies, I see it. Dr. Lightman, had his condition been promptly diagnosed and treated, it is my opinion that the resultant heart attack and lung injury would not have occurred. So that there is some evidence, I don't say it's very powerful, but there is some evidence to support the inference that delay will lead to increasing sepsis with increasing prospects of complications. At the very least, as I've already submitted, that evidence, together with Dr. Lightman's report, which was saying that all this would have been avoided if he'd been operated upon within 4 hours, 2 to 4 hours, as he said in his original report, had the the Bermuda Hospital Board wished to rebut the potential inference, as I've already submitted, they should have called evidence to do so. And as I've already submitted, they actually had a cardiologist, and no such evidence emanated from him. The cardiologist, as I've mentioned, named at paragraph 24, was Dr. Zussman, and his report was not directed to this point. He wasn't, I think I'm right in saying, was not called to give evidence, but he reported in the case, and his report was before the court.
Brown, I'm very sorry to harp on about this, but the inference that you say that the court may well have drawn, and if not, we should,
Yes.
is, as I understand it, that but for the extra and negligent delay, there would have been no complications.
Yes.
Not that the complications would have happened but been less severe, but that there would have been none.
Yes. Lord, the reason I invite the court the board, I beg your pardon, to draw that inference is, as I've already submitted, because at 1643, 1750, yes.
But that's now you're going to come, I imagine, to what happens if the correct inference is that you can't go that far, but you can at the very least say that it wouldn't have been as bad.
Yes, I am, and that's Bonington. and that was the topic to which I was, so having, as it were, set out my stall on, but for complete causation, if I can put it like that, may I come to Bonington? And I would just in passing, if I may respectfully mention it, respectfully remind the Court of the matters we have included within our written case as to the principles underpinning causation, because we respectfully submit that those considerations, that the need to find responsibility, the need not to over-refine the question of causation, A, is well established in the law, but B, when one comes to ask the questions which are sometimes expressed as being common sense, and sometimes according with ordinary moral notions, as expressed by Lord Hoffman, those are useful guidance, we respectfully submit, both in relation to the but-for questions, the robust but-for questions, but also when one comes to consider the question of Bonington. We come to Bonington within our written case at paragraph 60. And we respectfully submit that the novelty about Bonington is that, as your Lordship has rightly apprehended, Bonington entitles a claimant to succeed when they can't prove full but-for causation, but in a case such as this are able to prove that the negligence has been a more than minimal cause of at least part of the damage. We set out at paragraph 61 the basis upon which the Lord Reed's primary statements. My Lord, I think I should go to Bonington probably. It's in the volume 7, which is the core bundle.
Well, can I just check your formulation? You say Bonington establishes that liability will arise if the negligence has been more than a minimal cause of part of the damage. I thought earlier you were acceding to the proposition that it would apply if the negligent element was the but-for cause of part of the damage, but that's not your position.
Well, I think that means the same thing, doesn't it?
Well, but if it's more than a minimal cause, are you saying it's just it makes a contribution, or are you saying it's but-for?
I confess, my Lord, immediately, I've struggled with that question, because it seems to me, with respect, that whilst Bonington is clearly regarded as being a development in the law, at least one interpretation would be to say that Bonington is a conventional but-for causation case in which the court concludes that it is reasonable to infer that there is that the guilty silica in that case has added to the innocent silica, and that having made that inference, it has caused a part, therefore, of the loss, and it has caused, and having concluded that it's caused a part of the loss, where the damage, even if divisible, cannot sensibly be divided, then the claimant is entitled to recover in full. So, going back to an observation my Lady Hale made earlier, one of the questions that arises in relation to Bonington is that, of course, apportionment wasn't argued.
Yes.
But, of course, if it would have been scientifically impossible to establish causation, even approximately, because some of the silica might have been nastier than other of the silica and so on, there are all sorts of different areas, it could be that Bonington is also authority for the proposition that in such a theoretically divisible case, because it is practically indivisible, you are entitled to recover. If the inference can be drawn, you're entitled to recover for the whole of the damage. can I come on to Bonington? And it's, as I was saying, it's within the core bundle, which is bundle 7. It's under tab 2, and it's page
1117, I think.
3270, my lady, I hope. That's what we're told.
It may be in 2 different places.
I think it's in 2 different places, my
Yeah.
lady. I was going to go to the core bundle. I'd very happily go to the other one if it would be more,
You
if it would be more helpful.
carry on.
Yes, it's 2189 for those who are working from the hard copy. May I pick it up at the judgments, page 618, opinions. First of all, Viscount Simmons, I beg your pardon, who agrees with Lord Reed. Then we have Lord Reed, and the passages to which I'd invite the court's attention are, well, it's page 621 of the original appeal cases report. I hope that makes it locatable. The medical evidence was that pneumoconiosis is caused by a gradual accumulation in the lungs of minute particles of silica, inhaled over a period of years. That means, I think, that the disease is caused by the whole of the noxious material inhaled, and if that material comes from 2 sources, it cannot be wholly attributed to material from one source or the other. I'm in agreement with much of the Lord President's opinion in this case, but I cannot agree that the question is, which was the most probable source of the respondent's disease, the dust from the pneumatic hammers or the dust from the swing grinders? It appears to me that the source of his disease was the dust from both sources, and the real question is whether the dust from the swing grinders materially contributed to the disease. What is a material contribution must be a question of degree. A contribution which comes within the exception of de minimis non curat lex is not material, but I think that any contribution which does not fall within that exception must be material. I do not see how there can be something too large to come within the de minimis principle, yet too small to be material. As the Lord Ordinary did not deal with the case from this point of view, this is the point I was making a little earlier, I must deal with the evidence of fresh in the light and so on. So that was simply why I made that point. And then going on, if I may, to page 623, just before the end of the opinion, about 6 lines from the bottom of the opinion. In my opinion, it is proved not only that the swing grinders may well have contributed, but that they did in fact contribute a quota of silica dust, which was not negligible in the pursuer's lungs, and therefore did help to produce the disease. So that he's inferring that there was in fact a contribution to the damage arising out of the silica. Position is we respectfully submit clearer, or just as clear, perhaps clearer in the judgment of Lord Tucker, which immediately follows. It's the 2nd paragraph on the same page. In my opinion, the inference to be drawn from these facts is that the silica dust discharged from the swing grinders contributed to the harmful condition of the atmosphere, which admittedly resulted in the pursuer contracting pneumoconiosis, and was therefore a contributory cause of the disease. Lord Keith, page 626.
Before you go to him, Lord Tucker, there's a passage we might perhaps look at the 2nd paragraph of his judgment in hard copy 220, having set out the facts, the inference to be drawn from these facts.
You just read that, haven't you?
Oh, sorry, you've read that bit.
That's the part I'm seeking.
I'm so sorry, forgive me, I'm behind the curve. Did you get to the last paragraph of Tucker too?
I was just coming to that, my lord.
Right.
This is the question, because as will be recalled, it had been suggested before the case came to the House of Lords that there was a reversal of the burden of proof. And this is where Lord Tucker deals with that, and it's quite clear that this is the unanimous opinion, I think, of the House of Lords. But this is the last paragraph of Lord Tucker. My lords, I think it is desirable that your lordship should take this opportunity to state in plain terms that no such onus exists unless the statute or statutory regulations expressly or impliedly so provides, as in several instances it does. No distinction can be drawn between actions for common law negligence and actions for breach of statutory duty in this respect. In both, the plaintiff or pursuer must prove A, breach of duty, and B, that such breach caused the injury complained of. In each case, it will depend upon the particular facts proved and the proper inferences to be drawn therefrom, whether the pursuer has sufficiently discharged the onus that lies upon him. In the present case, I think he has, and on this ground, and without expressing any view on the subject of the alleged defective ventilation, I would dismiss the appeal. would just pause to make this observation, which I suspect is trite. The mere fact that the burden of proof is not reversed does not mean that a defendant can be excused from calling relevant evidence to displace inferences. That's perfectly obvious. Lord Keith of Avonholme.
This approach to the case was first taken in the House of Lords, was it?
Yes.
It wasn't taken either in the outer house or in the inner house.
No, my lord, it wasn't, and that's why, as I've already submitted, one can see that Lord Reid is saying at 621 that since neither the outer house nor the inner house have dealt with it on this basis, it's necessary for the House of Lords to consider afresh the factual findings, and that, of course, is the process which is going on, if I can put it in that way, from 621 down to I think it's the bottom of 622 and indeed on to 623, that Lord Reid is there considering what the evidence was, what the evidence established, and what inferences should be drawn from those evidence.
On the facts, the noxious material inhaled came from two sources at the same time, did it?
Yes.
And is that critical?
No.
Why not?
We respectfully submit, and perhaps I'll come to the basis for the submission, that so long as the two causes work together, it does not matter whether they are simultaneous or consecutive. The critical point is that they should be working together, or as Master of the Rolls observed in another case, synergistic. It's the process, the two aspects working hand in hand, if I can put it like that, together, rather than simultaneously, that is critical to the inquiry so far as Bonington is concerned.
So they could be separated by a very significant period, then, could they?
I suppose the answer...
As long as they both work together.
Yes, I suppose the answer to your Lordship's question is this, that the greater the period, the less likely it is that it will be established, but as a matter of theory, yes. Can I come to Lord Keith? Or may I come to Lord Keith? Page 626. At the first complete paragraph. On these facts, I think the pursuer has proved enough to associate his illness with the fault of the defenders, or at least to establish a prima facie presumption to that effect. The case for the defendants depends on the fact that the pursuer, as a steel dresser, engaged over the whole period of 8 years in operating a pneumatic hammer on steel castings, was exposed much more immediately and in a much greater measure to silica dust released from these castings. I'm prepared to agree, as did all the judges in the court below, that the main source of silica dust inhaled by the pursuer came from this operation, a cause for which it is agreed the defenders were in no way to blame. It was accordingly maintained, for the defenders, that the pursuer must show that the dust released from their negligence from the swing grinders had contributed materially to the dangerous dust inhaled by the pursuer, as there was no evidence to show the proportion of the dust emanating from the various sources of the dressing shop inhaled by the pursuer. His case, it was said, must fail. The pursuer has, however, in my opinion, proved enough to support the inference that the fault of the defenders has materially contributed to his illness. So the question that we respect...
Foot of the page, last 5 lines.
Yes, of course, my Lord. During the whole period of his employment...
Prima facie, the particles inhaled are acting cumulatively.
Prima facie, the particles inhaled are acting cumulatively, and I think the natural inference is that had it not been for the cumulative effect, the pursuer would not have developed pneumoconiosis when he did, and might not have developed it at all. The inference, of course, would have been different if it could be shown that the pursuer could not have inhaled any particles given off from the swing grinding operations, or that the particles negligently relieved from the swing grinding operations were released at intervals so infrequent, or in quantities so insignificant, that even if taken cumulatively as to make it unreasonable to regard them as a material contributing cause of the pursuer's disease. But that, in my opinion, the defendants are unable to show. On the whole evidence, I consider the pursuer has discharged the onus that is upon him of showing that the defender's fault was a material contributing cause of his illness. I would accordingly dismiss the appeal. So the question that we respectfully submit, or the principle that we respectfully submit, emerges from Bonington, is whether the claimant has proved enough to enable the court to infer that there was a material contribution to the damage suffered or not. You have my submissions on the facts of this case. I don't know, Lady, I fear I'm unlikely to finish in a few more minutes. I know the board normally rises at 4.
Well, we do normally rise at 4, and one or two of us have got meetings afterwards. How much longer do you think you have to go without holding you to it as a matter of...
Well, Lady, I would hope, it's difficult to say, certainly no more than an hour, and I would hope not as much. In other words, I would hope substantially within the 3 hours allotted. That's not said in any way into Rorem, but I obviously will think about the matter carefully overnight and
Yes,
cut
yes.
it down.
And for your reply, you've indented for half an hour in any event, haven't you?
It has, which would mean we would finish at 12:30, but I believe that the board's time allocated runs until 1, but we will only trespass as far as necessary.
Well, what I'm exploring is whether we need to start early tomorrow in view of the lost time today, and I think the answer is no, we don't.
No, I don't believe so.
Is that...
I'd love to, but don't worry. I think I'm in the minority.
Assume that we will start at 10:30 tomorrow unless you get a very speedy message to the contrary effect.
Thank you very much.
That will enable a democratic decision to be taken.
One thing I would welcome is your view on Professor Stapleton's thesis in unnecessary clauses.
I feared your lordship might welcome that.
Volume 6.
We'll adjourn now.